we ready? Yes. Okay, this is the Standing Committee on Citizenship and Immigration, meeting number 50, the orders of the day. Pursuant to Standing Order 1082, study of standing on guard for thee, ensuring that Canada's immigration system is secure. Just for the record, I just remind most people know what we did, but representatives of the committee in the context of this study on security, we visited the detention centers in Vancouver, Laval, and Rexdale, which were low risk, as well as one high risk detention center. We also visited the Immigration and Refugee Board of Canada, and I expect these issues will be debated in the report when we're ready to present the report to the House of Commons. So we have two witnesses before us today. One is on a video conference from Toronto, Mr. Lorne Waldman, who is a partner of Lorne Waldman and Associates. Good afternoon to you, sir. Sorry to keep you waiting.
Good afternoon.
We also have Nathalie Desrosiers, who is the General Counsel of the Canadian Civil Liberties Association. Good afternoon to you. You each will have up to 10 minutes to make a presentation to the committee, and then committee members will ask questions. This committee will end at 5:30. Ms. Desrosiers, you have the floor.
Merci beaucoup.
Thank you very much. The Canadian Civil Liberties Association thanks the committee for this invitation. The first part of my remarks will be in French and the second part in English. The Canadian Civil Liberties Association is a non-profit, nonpartisan association that was established in 1964 to protect the rights and civil liberties in Canada. It does awareness, advocacy, and engagement work before decision-making bodies like this one and before the courts. It is mainly volunteer-driven, lawyers throughout the country. I will be focusing on three matters in my remarks that were raised in the context of your report. First of all, the first suggestion is the need for an independent accountability regime for the Canada Border Services Agency. The second is the difficult matter of persons suspected of war crimes or crimes against humanity. And third, briefly, I will be dealing with certain aspects of the security clearance regime. First off, our association is always, of course, interested in standards, procedures, and legal procedures to ensure that people are fairly treated in Canada. Increasingly, binding authorities are being granted to the CBSA, the Canada Border Services Agency, and its oversight regime is a bit of an anomaly in Canada. CSIS has an oversight regime. The RCMP does as well, and we note the efforts currently being put forward in the House of Commons in order to improve the RCMP's oversight regime. But the border services do not have this. There is an internal complaints process, but that's not sufficient in the context where increasingly binding authorities are granted to these agencies. In a democracy, one must always remember to connect broader powers or increased discretion with a bit of an oversight scheme. It is important to consider this when we think about the importance of Canadians' trust and confidence in this regime.
Examples just to show how necessary this might be, but in short, there is a gap in our accountability framework where you have CSIS as independent supervision, the RCMP now it will have an even better one, but CBSA does not. And we have many people that call us that we encouraged them to use the internal mechanism for complaints, and it has not been satisfactory. So in our view, it would just be part of the regime of increasing powers at the border to ensure that indeed there's some accountability framework around this. Asking for oversight is not because we suspect foul play or bad form. It's just the right thing to do in a democracy, which is good governance. And in our view, it's not necessary to create a new agency. That wouldn't be very popular to talk about that now. But we might be able to enlarge the mandate of some of the current agencies. So I urge you to reflect on this as you move forward in your recommendation. Deuxièmement, the difficult issue of persons suspected of war crimes or crimes against humanity. CCLA, like other human rights organizations, is fully engaged in the fight against impunity. It's absolutely essential that people who may have committed crimes of war or crimes against humanity be brought to justice and tried properly. And similarly, people who are innocent of such crimes should be vindicated and should be cleared. So the obligations of Canada on this score are important, and I will urge the committee to engage as parliamentarians to ask more information on this context. That will be my pitch to you. In a way, I think what CCLA recommends is that we should have a policy to extradite or prosecute people suspected of crime, not simply to deport them. In a way, I think simply deporting them, if you is like passing the buck. In a way, it's not owning up to our responsibilities to ensure that crime against humanities are fully prosecuted. So we certainly want an immigration regime that's good for Canada, and it also has to be good for the world. And every day, Canadians around the globe are subject to injustices at the hands of dictatorships, and it's incumbent upon us to make sure that indeed crimes against war crimes or crimes against humanity are fully prosecuted. CCLA will be intervening in the Ezokola case, and I know that Mr. Warman will be there as well, which hopefully will clarify some of the standards of proof that are necessary to exclude someone from the protection of a refugee because he or she is suspected of war crimes or crimes against humanity. And I would urge you to continue to consider, I think, the necessity to ensure that there's some fundamental justice in the way in which these decisions are made. So it's a difficult question. There's no doubt that different cases raise different factuals. Not everyone can be extradited because there are places where they won't be tried fairly. There are places where they will be tortured or suffer persecution. But prosecution should be our duty here. And I urge you as parliamentarians that you demand reporting mechanisms from the ministry to ensure that the decision not to prosecute or not to extradite and instead to deport is reached really as a last resort, only in the clearest of cases. And in our view, I think we think there's a lack of transparency here that you may want to explore further in your report. In our view, we owe it to the world to carry this responsibility forcefully. Finalement, security clearances and generally, I think norms of procedural fairness is what I'm going to talk about in the end. CCLA has a long tradition to ensure that we need to treat people fairly in Canada. That's what we're all about, and we have to continue to do that. So I think it's important that we have similar norms of justice, no matter who it is that is being treated in Canada. Whether and I think so any times that there's a depletion of the justice requirement, I think we should be worried and actually insist that norms of fundamental justice continue to be maintained throughout the system. So I urge you to put that as a principle of your recommendation. So last week we issued a report on police checks. which essentially was about the way in which many people who are not found guilty have information about withdrawn charges or even a verdict of not guilty being disclosed in the context of police checks for employment for vulnerable sector and so on. And it has prompted lots of calls throughout Canada. We've had many calls, and the reason why I raise it here is because many of the calls were about security clearance. So I thought I would share with you some of the stories and the issues that have come up. Alors, essentiellement, notre conclusion.
So essentially, in closing, the security clearance system must be subject to oversight. It could be the Privacy Commissioner who could do this, or another agency, to make sure that the quality of the process for managing information be adequate, and that there be enough in place to correct the information. Sometimes, on occasion, people might be victims of poor information management, and this can have severe consequences on their ability to work or travel. We believe that the process for correcting and the standards of procedural fairness, all of this that surrounds the security clearance process must be strengthened and be made more transparent in the eyes of Canadians, for Canadians and all those living in Canada.
About the way in which the issue is not so much, and in my view, I think from our consultations that we did with the police sector and the security sector, I think it's not a question of a polarized debate. It's more a question that clarity is needed. There's some ambiguity in the law, and I think it needs to be clarified. Everybody would be better off if they knew better what their obligations were in terms of privacy, and I conclude on that.
Thank you very much. Mr. Waldman, it's your turn.
Thank you very much. I'll try and be brief. I'm going to pick up on a few topics that Ms. Durocher touched on. And first and foremost, I would like to address the issue of the accountability regime. Commissioner O'Connor in the Arar report recommended many years ago, I think it was in 2005 or 6, that there be a oversight of the activities of the Canadian Border Services, especially in relation to national security operations. Unfortunately, those recommendations, although government initially said they supported them, haven't been implemented. And it highlights a broader problem that my colleague just mentioned. Border Services agencies have very broad enforcement powers. They have very broad powers of arrest, search and seizure, detention. And these powers are not subject to any independent oversight by any oversight body. So we often get complaints from clients about the conduct of CBSA officers. The complaints may or may not be well-founded, but the important fact is that it's important that if there's a serious complaint of misconduct, that there be a mechanism for verifying. That's the only way in our democracy where we have the rule of law that we can ensure that there is accountability. And really there is no independent accountability regime vis-a-vis Canadian Border Service Agency, and this is a very serious problem. I mean, I now am involved in a dispute with the Border Services Agency over their authority to force one of my clients to attend an interview, and they insisted, and I'm now going to court. It's the only way I can resolve this dispute because there is no independent mechanism for arbitrating. It seems to be an expensive way of trying to determine the limits and scope of authority of Border Services agencies. In terms of my friend's comments on war crimes, I'll just pick up on one point on that. And I agree with the idea that the Immigration Act has to be enforced, and I also agree with the idea that it's the duty of our government to ensure that people who are wanted and who have failed to appear for deportation should be apprehended. But sometimes the methodologies used are counterproductive, and I should say that in the case of the most wanted list for war criminals, that really has produced situations where people who could have been deported now may not be able to be deported, because we live in an age today where the publicity that occurs when governments like Canada's make statements is huge, and the internet makes this information accessible. So I'm involved in a case now of one of the person who was on the list who is now in a situation where we have asserted, and an immigration official has agreed, he would be at risk if he were deported. So the idea of a most wanted list publishing people who are wanted for war crimes, I think, was ill-conceived. I don't have the same concerns about other types of most wanted lists. The third issue that I do want to speak about briefly, and then I'll stop and leave it open for questions, is the question of detention. I thought that was really one of the focuses of today's meeting. You know, I've been doing immigration law for longer than I would care to admit. It's over 25 years, and I've seen the incredible increase in the use of detention by immigration authorities. Some of that is necessary because, you know, we're in a world today where many people are being coming to Canada. It's more difficult to find out who they are. The prevalence of false documentation is higher. And certainly it may be necessary to detain people until we know who they are. And because if we don't know who they are, we can't really ascertain whether they or not they pose a danger to society. And certainly it may be necessary to detain people who pose a danger to society. But we're seeing detention used in a lot of other circumstances where people don't pose a danger and where we know who they are. And this is of particular concern, A, because of the impact of detention on the individuals, many of whom are, I mean, you visited the Rexdale facility, which is a minimum security. I don't know if you had an opportunity of going to the Toronto West Detention Centre, which is the maximum security facility where a lot of the immigration detainees are held. And I can tell you it's a very demoralizing, depressing place for a person to be detained, because it's a holding facility for people waiting pretrial. There are no facilities for any kinds of activities there at all, and immigration detainees don't get any access to any of the facilities. So it's, I mean, and we have people that are being held in immigration detention for 1 or 2 years in conditions like that. But of even more concern to me is the issue of detention of children. You know, there are children who are being detained, and granted, if you went to Rexdale, I'm sure you saw children there, and it's completely unacceptable that the children are being detained and that they're not getting any kind of access to services that should be made available to them. And I'm very concerned about the impact that detention is having on children who find themselves in detention because their parents are being detained. I'll stop here, and I'll be, there's a lot more we could say about detention. I mean, the one other point I want to make is that detention is extremely expensive, and the government should be considering all of the different alternatives to detention. I've used electronic monitoring as an alternative to detention. We have a bail project in Toronto, which is an alternative to detention, but it's not being used enough, and it should be used more. I mean, we have to creatively look at different ways to ensure that people who should be under some kind of monitoring are kept under monitoring, but in ways that don't require them to be detained in the immigration facilities because of the expense and because of the impact on the individuals. That's all I'll say for now. Thank you.
Thank you, Mr. Waldman. Ms. James.
Thank you, Mr. Chairman. Congratulations on your appointment to chair once again, and thank you to both of our guests for your presentations. I'm going to direct my first part of my questions to Ms. Desrosiers. And there was something that you said, and I think I need to have a bit of clarification on it, because I think that you said you preferred extraditing war criminals instead of deporting them. And are you talking about if someone has come to Canada who is a war criminal or terrorist or whatever the case may be, they have physically left Canada, are you asking us to bring them back, to try them here? I'm not fully understanding that.
Okay. So the question, the obligation is to prosecute people at the place where there is the resources to prosecute them. And at times, it could be that you need to send them to the place where they are ready to prosecute them.
So are you saying...
Reverse, that what you're saying is not bringing them back, But
Okay, so you're saying if there is a known criminal or war criminal, so let me ask the question, please. If there's a war criminal or terrorist known, and we deem that he's here in Canadian soil, you're saying we should try him here for his crimes in another country, as opposed to deporting him back to that country to face charges there?
You have both options. First of all, people
which is the one that you're saying, though? I just need to ask because I'm going to lead into another question, so I'm just curious to know.
It's both. I suggested both options be the ones that the government has in front of it. The idea is people are presumed innocent. You have to have evidence.
Okay, let me just reword it.
Okay.
If someone was a known terrorist, convicted war crime criminal, and was outside of Canada, would you bring them back, yes or no? Is that no? And if they were here, you'd want to try them before deporting them, yes or no?
Yes.
Okay, I'm just going to lead into actually a particular case I have in front of me. It has to deal with a gentleman, Mahmoud Mohammed Isaiah Mohammed, who carried out terrorist acts with the Popular Front for the Liberation of Palestine. Now, this person's in Canada. You're saying that we should try them here as opposed to deporting them?
There's a different. Extraditing someone is to send them to another country where they can be tried and charged.
Right, but if they're here, you're saying we should be trying him on whatever acts of terrorism?
If we have the resources to do that.
Okay, I just want to... he's actually... His connection to terrorism was established a long time ago, and he's actually still in Canada. He's been here since 1987. And he is actually... in the process or continuing to launch series of judicial appeals. And I'm just, I'm thinking that you're saying we should try him here for war crimes, and then we should allow him go through all this judicial review, so on. Can I just ask, is that what you're saying we should be doing, or do you not think that we should just simply deport this person?
I think we have to be clear that if we need evidence of people, we need to deal with them on the basis of evidence. So if you have evidence, then certainly I think deportation is one possibility. One of the obligations that you have is if they have not been convicted, is to prosecute them. That's why I'm saying.
Okay, I just want to add to this particular case. His presence in Canada since 1987 and his launch of a series of judicial appeals has cost Canadian taxpayers $3 million. So, I mean, when I actually learned of this, I'm looking at it, and I actually asked if it was a typo, because I couldn't believe it myself. So I'm very concerned when I hear witnesses state that we should be trying these particular criminals here in Canada and then allowing them to go through judicial appeals. And we're talking 1987. It's now 2012. That's a long time. And I'm sure that there isn't a single person that's watching this committee right now that would agree that this is actually the way to go. So I'm very concerned about that. But getting back to the actual screening policies, I'm just wondering what recommendations you would make to correct the flaws in Canada's screening policies. And I know you've talked about an independent regime to deal with complaints, but I'm not talking about complaints. I'm talking about how can we better screen people coming into Canada.
I think there's the obligation of correcting the bad information. The Privacy Commissioner of Ontario recently published an article to recognize how bad information creeps in to data, and she recommends that people be able to trace back where the information comes from to ensure that they have the possibility of correcting it. So that's one of the issue. It's important that we ensure that people that we base decisions on the correct information.
And you would agree that it's better to stop someone from coming into Canada than having them here and costing taxpayers $3 million, correct?
If it's the correct information, I have no problem with it.
Thank you. Just a second thing. Do you think that so far we have been good, Canada as a whole, at our border crossings and so on, that we've done a fairly good job of screening people and preventing criminals from entering our borders? I mean, I read this one example. I know there's a dozen more. Do you think that there's room for improvement, that we really need to crack down, do better screening?
There's always room for improvement. Certainly, that's not the position. I think we have to be continuing to improve regimes to ensure that we have correct information, that we have procedural fairness attached to this, so that we are certain that we are acting on the best interest. It's not to the interest of anyone if we're acting on the wrong information. So my point is, certainement, there's always room for improvement.
And you're going back to correcting bad information or making sure we have the correct information, but how do we actually go about that? What is the recommendation to actually make sure that that information is correct?
Well, I draw from the privacy commissioners, which suggests that people have the ability to challenge information about themselves, know where it comes from. And in that context, you need to have some procedural norms around this. So I think that's where we're going, is to ensure that there is a way in which people can respond to the information about them to ensure that it's correct.
Thank you, Ms. James. Madame Gregouille.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. I'd like to start by thanking our witnesses. My first question is for Mr. Waldman. Sending people accused of crimes back to their countries can pose risk of torture, etc. In what way should these removals try to find a balance between protecting the safety of Canadians and the concerns of human rights in a state of law like Canada?
Well, thank you for that question, because I think it picks up on the question of the previous speaker. The case that she cited was a case involving a gentleman who had already been convicted. So it's a different situation from the situation we're discussing here. We're generally speaking about people who have been accused of war crimes or crimes against humanity, but who haven't yet been convicted. And the question is, they may have been found by an immigration member at a very low threshold, because remember, there's 3 thresholds, and the immigration threshold of proof is less than a balance of probability. So it's a very low threshold of proof. It wouldn't withstand, it wouldn't be enough to find a person guilty. So we are dealing with people who have been found war criminals at a very low threshold, and then we have to decide what to do with them. And as the previous speaker said, there are circumstances when we should consider trying them in Canada. And that, I can give you one example, and that was one of the gentlemen was actually deported from the most wanted list. He was from Honduras. And in fact, Honduran human rights groups contacted many people in Canada and said, don't send this gentleman home, because if he gets home, he won't be tried. He'll be free, and he is really someone who should be tried. We have evidence to prove that he may well be a war criminal. Please keep him in Canada. That's a type of example of a case where we should, if we are committed to really holding people accountable, we should seek to try them in Canada. The other example you gave, of course, is of people who are war criminals and who can't be deported, because to deport them would be to risk subjecting them to torture. And that's one of the case I'm dealing with now. And in those types of situations, we have to consider the possibility, if we believe that they really are war criminals, of trying them in Canada, because they can't be tried. And now, of course, we have the International Criminal Court, and that gives us another option. If we believe that a person is a war criminal and he can't be sent home because he won't get a fair trial or he'll be tortured in his country, it's possible to ask the International Criminal Court to consider dealing with those cases. I mean, it's a very complex question, and it's not one that has a simple answer.
Okay.
Okay, I have a second question. You addressed the issue of accountability. Of course, for there to be good governance, you propose in this area an independent accountability regime. Could you elaborate a little bit on that point? Yes, it's for Mr. Waldman. You also, in fact, right?
Yeah, okay. I'll be briefly. We need to create an independent regime that people can make complaints to about the conduct of officials of CBSA that would have the power have powers to conduct hearings and hold inquiries to determine whether or not there have been abuses of persons' rights. It's a basic fundamental right that exists in every other context. CBSA officials have huge powers, and they need to. There has to be an accountability regime for them as well as other officials. It's a basic principle of the rule of law, and I'm sure my friend Mr. Rocher has more to say.
Accountability regimes need to have these qualities. They must be independent, there must be a civil side to it. In other words, it's not someone internally that can address the issues. There needs to be an audit ability. In other words, you need to be able to carry out audits not only on the basis of complaints, but also on their own initiative to make sure that the policies and the rights are respected. What we're asking for, essentially, is to make sure that we have a regime. Well, we have one for CSIS. We have something that's improving also for the RCMP, an oversight regime, and we would need the same type of thing for the CBSA because they have serious powers.
Oh, OK. OK. Concernant le...
Mr. Waldman, you addressed the growing cases of detention from year to year, number of cases of detention, and you also mentioned some alternatives to detention. You quoted a number, you referred to a number of models, but would you suggest one more so than another?
Well, you know, the issue of detention is complex because it really depends on the reason for the detention, right? There are two fundamental reasons why we detain people in immigration. One is because we think that they may be dangerous. And they may be dangerous because they're criminal, have a criminal background, a terrorist background, or we may just detain them because at the specific time when they come to Canada, we're not sure who they are, and we're concerned they might be dangerous. That's one ground, and we have to be very careful in those circumstances, right? In terms of this other reason why we detain people, it's in order to ensure that they appear for hearings. And in that context, the concerns are less. You know, it's really just a matter that if we don't detain them, maybe we're going to have to find them, and there's going to be an expense attached. On the other hand, so the options depend. You know, when you're talking, one of my clients was accused of being a member of Al Qaeda. He was ultimately cleared after 8 years. And he was released under electronic monitoring, camera surveillance in his house, a whole series of conditions. Other clients, who aren't dangerous can be released with some kind of simple weekly reporting. The Bail Project, which is something that I think is financed by the government, I'm pretty sure it's financed by the government, is a very inexpensive way of ensuring compliance, and it's a way where people register with this project. It's funded by the government, and the Bail Project then acts as an intermediary between the government and CBSA to ensure that people comply with the conditions, and if they don't comply, the Bail Project tells the government, and the people are taken back into detention. So there are different options depending on the seriousness of the case.
Thank you. Mr. Lamoureux.
Mr. Waldman, actually I have two quick comments. One for Natalie in regards to Bill 43, C-43, in which I'm sure she's quite familiar with. I would be very much interested in hearing some of her thoughts in regards to that particular bill. Not this afternoon, but maybe we could even provide an opportunity to get your understanding of that bill. But Mr. Waldman, it's just to continue with what you just referred to. The Bail Project, electronic monitoring, I think are wonderful things. The problem with the Bail Project is it only applies in Ontario. Would you think that there's something that we should be doing within Ottawa to ensure that BC and Quebec have a similar program? What I wanted to hear from you more so is you have 100% confidence in the Bail Project and being able to be alternative to detention, and you do see a role in terms of the electronic monitoring, correct?
Well, all of these are alternatives. All of them, when I offer my clients a choice, stay in Toronto West Detention Centre or go out under electronic monitoring, they're all going to agree to go out under electronic monitoring, right? It's not that expensive. It gives the government an opportunity to know where people are if they're concerned they're going to disappear, and if they take action to cut the monitoring equipment off, the government gets an immediate warning and is aware that they've absconded and can take action immediately. So it's better than nothing, and it's not bail-proof for sure. Bail Project is another example. For sure, we should have the Bail Project across the country. It's an inexpensive way of finding an alternative to detention. No doubt about it.
Your turn, sir.
Oh, thank you, Chair. My question is for Mr. Wallman. Mr. Wallman, in a society where we live, where technology is so advanced that we talk about electronic monitoring and so on, my question is more of a fairly straightforward one. If a person comes in and he's not documented, we don't know who he is, we don't know why, we know how he got in, he flew in or something, then isn't it the responsibility of, as Canadians, as parliamentarians, to ensure that we understand all that information first through, interviews and questioning and perhaps our links to Interpol and foreign governments before we even allow them into the society in general? Because I hear that if you let them in, even though it's on a bail program or on a electronic monitoring, it's still potentially can be a risk factor to Canadians.
Well, I agree with you. I mean, that's one of the points I made. One of the primary grounds of detention is if we don't know the identity of the person. The onus is on the individual to establish his identity. And if he doesn't, then he can be kept in detention until he does. And so we have, when the people came off of the boat, for example, is a good example. Most of them didn't have proper identity documents. They were held for 2-3 months, and by the end of 3 months, family members had gotten identity documents that satisfied immigration officials who they were, and at that point we could move on to see them released. And so there's absolutely no doubt we shouldn't. It's a valid reason to hold someone in detention if we don't know who they are and we are concerned that based upon what we suspect they may be dangerous. And the Immigration Act already provides for detention on those grounds.
Don't we also have the right, or maybe perhaps it's not a right, but shouldn't we also just turn them around, put it on the next plane back? Because if they come into this country without proper documentation, it will appear to me that they have violated our immigration laws.
Well, I guess that depends on why they've come and what they say. If we don't know who they are, but if they say that they're at risk of persecution if we send them back to where they came from, then we have an obligation under the United Nations Refugee Convention to consider if their fear is valid or not before we send them back, because we don't want to be complicit in sending someone back to be tortured. And so if they just say I want to come and visit, people get routinely turned around if we're not satisfied who they are. But once they make claims of persecution, we have to adjudicate those before we send them back.
Mr. Long, Ms. DeRosier wanted to comment.
Yes, please.
I just wanted to clarify. Under the Conventions on the Status of Refugee, you cannot if somebody is claiming a refugee status, the fact that they don't have any papers cannot be held against them because it may be the circumstances how they left. So you have to be a bit careful just to assume that the failure of providing identification is enough to turn them back. So you have to have more than that. So I just want to, and certainly I think we want to comply with the convention. So that was my point, just a clarification.
Fine. I appreciate your comment or clarification. I have trouble with the fact that if a person has the documentation to board a plane somewhere, and he arrives on our border and then all of a sudden does not have documentation, to me that signifies some sort of ill intent, and that's and during our visit to the various detention centers, we've seen cases of that. Now, what I will say is that if they come in, on a board aboard a boat like the one that just came in from not the one, the MV Sunshine. To me, that's also people coming in with ill intent and trying to circumvent, our system. So in that case, I do think that it is necessary for us to take a little firmer attitude in determining their identity and intent.
My point was simply, I think we have to be careful in the way we frame this to make sure that we are complying.
If that's the case, how would you frame it? How would you suggest we frame it?
I think once someone has claimed refugee status, we have the obligation to adjudicate. The question of credibility, as you point out, is certainly relevant to that. But I think that's so you need to adjudicate. I think, as Lauren said, I think before you pack them up, you need to adjudicate. And my point was simply to clarify that obviously we want to be in compliance with the international convention.
I see. Share my time.
About a minute and a half.
Oh, a minute and a half. Well, then the next question has to do with, if a person destroys his identity on air coming back. I mean, we now have the ability overseas to know what documentation they have and so on. And as they come in, we know that they have a passport. We know that they had a passport that they get on, and then they simply destroyed it, ate it, or flush it away. To me, that signifies that there was intent to do something illegal, and that is to enter this country and claim, political asylum as a way of, getting in to see whether they can drag this process out to stay here. And again, to me, that appears to signify. It is hard in court law to determine credibility, but it is also the actions that they have taken that would make me very suspicious.
The actions are relevant to credibility. It's one of the elements that would be looked at. So.
Okay, that's one question.
Thank you, Mr. Chair, and thank you to both our witnesses. My question, I guess, my first one would be for Natalie, if I may call you that. You mentioned you were talking a lot about oversight and the need for oversight mechanisms. Can you share some specific incidents where oversight and oversight mechanisms would have been helpful and may have prevented an incident from occurring? You also mentioned gaps in accountabilities and insufficiencies, and if you could just provide examples or expand on those, because you touched on them very briefly in your opening.
Yes, certainly. I think people that have been treated at the border in a way that would have been inappropriate, either they were mishandled, or they suspect or they think that they have been the subject of either racial profiling or social profiling or so on. So they have concerns. They call CCLA, they call us to say, what do I do? I witnessed somebody that was actually very inappropriate to somebody else. This ought not to happen. And so generally what we tell them is, go on the website, there's a complaint form, fill the complaint form. One of the issues that arise is that this is very internal complaint forms. Many times their impression is that everything is being kind of washed over. It takes a long time. Nothing is being done that changes that. So we have people that say, they cross the border often, and then they say it has not improved.
So when you mentioned website, this is the CBSA's website.
Okay. CBSA's website. There is there's a complaint form that you can fill.
Okay. Sorry, go ahead.
So I think our suggestion is that it's just good governance, good policy to ensure that if you have extensive powers given to an organization, that there's a way in which the regime self-corrects. So you have oversight mechanisms where you can have indeed a body, and it does not need to be a new body. It could be an expanded of that. On occasion will draw attentions to failure of obeying procedures. It's helpful to have oversight. It's helpful for people to think that they've been treated fairly. That the process is fair, is reasonable, is not from the inside. It has some external validation. So we have crossed that bridge on pretty much all security and policing in Canada. This is a holdout. There's no reason for it. It's just, I think we should just do it because that's good governance. It's essential. It helps the agency itself, and it helps people having more confidence in it.
So, in your view or your stats, like the CBSA seems to be the only organization that doesn't have this oversight?
There's varying degrees of oversight. Some there's more civilian oversight.
Right.
Some have less. Some have more powers. And certainly I think we have some comments on the best oversight mechanism. But for us, I think it would be important here not to be only complaints driven, because many people are afraid of complaining against the CBSA, because they're afraid that their names will be called up the next time they come up, and then they will be treated. Then they will have to wait way longer. So I think the idea of ensuring that indeed there is some good oversight, to us, this is appropriate in this context. We've done it elsewhere. It's good for governance. We should just do it.
Okay, thank you. You mentioned we were talking about detention a little bit. I know I don't have too much more time, so we have 1 minute. If you want to talk about some of the alternatives to detention, and especially for children.
Certainly, I think the detention of children raises violations of convention, and it's just not good policy. It may impact their ability to fully adapt to Canada. So I think any alternative in that sort should be. So I think bail, any mechanisms that saves money and that complies. We just have to be more creative. We have done that in other sectors. We're doing it in the criminal justice system constantly. It's not perfect. But I think the idea of being innovative in this context to recognize the need for security, the protection of individual rights, but also the fact that there's a real loss in detentions for the adaptation of people to Canada. It's a loss of their life for years and so on. So.
And what would be the age of when you spoke of
16.
Children?
But I think the Convention under the Rights of the Child is 18. And
Thank you. Mr. Weston.
Merci, Monsieur le Président, et bienvenue.
Thank you, Mr. Chairman. Welcome to my colleagues from the law profession. Viktor Frankl said, freedom without responsibility is dangerous. In other words, there always needs to be a balance that is struck. If we're always focused on protecting rights, I would like to ask you, what would be our Minister of Citizenship and Immigration's responsibility to counter terrorism? At the same time as we do want to maintain our openness to the world, this might be a bit of a different question I'm asking you. What should our minister do for our security? And I'll be asking Mr. Waldman the same question in a moment. Well, certainly the Canadian Civil Liberties Association, in all of its positions, always recognizes the fact that there are varying interests that need to be reconciled. The protection of Canadians is a crucial interest, of course. Protecting security and safety requires rights and the rule of law. Misinformation is not going to be of any help to anyone. We need to make sure that procedures are well designed, include accountability mechanisms, and really respond to the imperatives that are to protect the rights of Canadians and the security or safety of Canadians. So the first thing I would do if I were minister is that I would create this accountability regime, because that is a source of information. It's also a source of accountability or responsibility, and on both sides it will protect rights and also our objectives. Our time is so short. Mr. Waldman, do you have any specific suggestions to counter terrorism?
A lot and deal with a lot of different files. I see the CBSA going after individuals where it makes absolutely no sense that they do, only because they can. And quite frankly, I'm profoundly disturbed about the huge amount of wasted resources. I could give you an example of one that just pops into my mind. A gentleman from Iran who was a supporter of an organization called the Kurdish Democratic Party of Iran, who was trying to get autonomy for the Kurds in Iran and was opposed to the regime from which we just broke off diplomatic relations, right? The Iranian government. Surprisingly, CBSA decided they wanted to deport this man back to Iran because he supports an organization that is opposed to the Iranian government. Why would we the organization has never been accused of involved in any terrorism activities at all of any shape, and there was no allegation that he had committed any acts of violence or terrorism. I'm just saying this because what we see time and time again is CBSA officials going after people because they can when there's no rational reason and expending huge amounts of resources on cases where they shouldn't. There has to be...
Mr. Malva, if I can just interrupt, my question was, what would you suggest to the minister to do? I know that organization is in this gray area. It has been rightly or wrongly associated with terrorist activities in past, and so there may have been unfairness, but we can't get into that individual case. My question is, what would you say to the minister to protect us against terrorism?
What we need to do is to ensure that there is a quality control at the highest levels of CBSA to ensure that the people are going after the appropriate cases and not going after individuals that they shouldn't go after. And I see huge waste of resources, and I can assure you I could sit down with you in a totally nonpartisan way and give you 10 examples of cases that are costing the government hundreds of thousands of dollars, and when you heard about the cases you would pull your hair out.
Mais si j'étais le ministre, je pense que...
But if I were the minister, I would feel that this is not much help to me. There's nothing very specific that you're suggesting there. Can I ask the question of Mrs. Desrosiers? For visitors, the Conservative government has allowed far more visitors into Canada than in the past. There's a 13% increase if you compare today's figures to the statistics of 2005. So what do? We want to continue to have doors open to visitors, but also protect ourselves against terrorism. I think protection against terrorism is always an intelligence issue or CSIS issue.
And I think we continue to invest and ensure that they are working to the best of their abilities. You will not be able to protect against terrorism without some intelligence, some form of knowledge about what's going on. So we need just better knowledge, continued vigilance, and continued participation at international law to ensure that there's no solution. You can't close your doors because we live in a worldwide world. You just keep supporting the mechanism that you have, ensure that they work well. That's why we're suggesting improve them by having accountability around them.
Sorry, I'm going to have to close the door.
Pardon.
Mr. Menegakis, unless you want to give your time to... Go ahead.
No, c'est bon.
You want to finish?
No, I'm done. Thank you.
Well, thank you very much, Mr. Chair. I want to thank our witnesses for being here with us today and sharing the legal perspective on this thing. As you may well know, we're currently studying security, and it's obvious from your testimony so far that you have a fairly intricate knowledge of our processes and people coming in the country. So I want to ask you a few questions as they relate to what we're currently doing, and perhaps get your feedback on where you think there are some deficiencies or where we can improve. Specifically, can you name some of the specific deficiencies that exist in the measures that we use to identify foreign nationals who may be inadmissible for a variety of reasons, be they health, safety, or security reasons?
Is that question addressed to me?
Well, both.
To me?
Yeah, sure. I'll start with you, Mr. Waldman. Maybe you can tell us how we can, where there are some deficiencies at the moment.
Well, as Ms. DeRoche said, when we're talking about trying to detect people who may pose a danger for whatever reason prior to their coming into Canada, there are only two ways we can do that. One is if we impose a visitor visa requirement, we have an opportunity at that point to screen the individual, and that gives us an opportunity to check with intelligence agencies, and if we are concerned about their health, to require them to do a medical. The difficulty with imposing visitor visa requirements is it costs a lot of money and it impedes our tourism and our ability of people to come into Canada, so we have to be selective. But obviously, if we required everyone in the world to get a tourist visa, then we would be able to pre-screen every person before they came to Canada. So there's a balance between the costs of doing that and the effect. Clearly that would be the most efficient way of trying to protect our society. But we don't do that because it costs too much money. We don't have the resources, and we can't afford to close our doors in that kind of way. The second way we can improve is by improving our intelligence sharing, and this is an issue that has been discussed repeatedly, and hopefully the intelligence agencies have made steps. There's still a lot of steps that need to be made, and we have to ensure that we share intelligence. We get reliable intelligence from agencies that are reliable, and so those are the two ways that I think we could improve our methods of ensuring that undesirable people don't get into Canada.
Would you care to add something to that, Mr. Rossi?
It seems to me that the idea is you always, the security, we have another committee where I appear where we talk about security, and I think there's certainly a coordination between the two. I think the work that is being done to ensure the right balance must continue to be done.
This is our study. This is why you were called here as witnesses, to comment on giving us information that could be valuable in preparing our assessment of the situation and what we would like to do. One of the things we've been looking at is biometrics. And I'd like to hear your comments, hopefully from both of you, on whether you think that would be an effective tool in preventing fraud and keep security threats out of our country. Because I'm sure you, like the rest of us, would not want security risks in our neighborhoods, around our families, walking the streets and shopping where we shop and so forth. So perhaps you can give me your feedback on biometrics. We'll start with you, Mr. Rossi, at this time, and then we'll go to Mr. Waldman.
Well, every mechanism to determine people's identity is not in itself wrong. What you have to ensure is that there are some procedural safeguards around, and that you balance the privacy interests of people and so on. So we always want to have accountability. For us, accountability is good governance. Due process is good governance. And that's, I think, how you have to. And you don't want discrimination, because that's wrong. It's the wrong message.
Nobody's talking about that.
So that's the important. So you need to ensure that it's being deployed in a context where you meet accountability needs, you meet good governance, legality, and we also think that there should be a prior assessment by the privacy commissioners of how to manage the data bank to ensure that it cannot be hacked, that it's being done properly. So that has always been our work within a governance and an accountability framework.
But its effectiveness as a tool in identifying who the person is. I mean, let's make the assumption. We'll make the assumption that the legalities. I mean, we can bring all kinds of lawyers here, and I'm sure we'll get the same kind of information coming out, and with respect. Mr. Waldman, would you care to give me your opinion on the effectiveness of biometrics and whether you think it would be a good tool to be used by CSA and CSIS and so forth?
Well, we've already seen, for example, when I started, people weren't even being fingerprinted. Now, more recently, people are fingerprinted, and the use of fingerprints has proved to be an effective way of detecting fraud and being able to identify people. So obviously, using biometrics appropriately and correct in a fashion that respects privacy is not a bad idea. Having said that, sorry.
Oh, I'm sorry. No, I apologize. Go ahead, sir.
Just one more thing. Having said that, it would be vitally important if we're going to start talking about using biometrics, to ensure two things. One is that accountability mechanisms, because without accountability, when you're now further increasing the power of CBSA, it would be extremely dangerous. You would have to also, I think, be very careful about how we did it so as to protect privacy concerns, and that would require detailed and careful consultation with the Privacy Commissioner.
Thank you very much. Thank you, Mr. Waldman.
Well, it's not a bad idea.
Thank you. Madame Gregouet.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. According to a witness, the criminals that are on Canadian soil should be prosecuted either in Canada or in their country of origin. What do you think of this, specifically for asylum seekers who are have been found to be criminals, but not beyond a reasonable doubt, but rather on a balance of probabilities? If there are reasons to believe that these people have committed a crime.
Donc c'est très spécifique.
So it's quite specific. Ms. Desrosiers, you addressed the same issue. Perhaps you could both give me your answers to this. Certainly, the standard is not sufficient under the Act to respond to the need for justice in Canada. We do not want, our obligation that we should take seriously certainly is that Canada is a part of a world that does not want war criminals to be free or not to be prosecuted. The obligation is to prosecute, to share the evidence, to make sure that people are brought before the responsible courts, whether we're talking about the International Court or a court in the other country or in Canada, rather than let things continue along a path of innuendo, rather than allow them essentially to get off scot-free without us taking our responsibilities. And that's exactly what we do with everyone here in Canada. If there are allegations, we prosecute. We present them before the courts. We bring them to justice. And then we see what happens. And so people can be found guilty or not guilty. We want to be fair on both sides. If someone is found guilty, that person certainly must pay for his or her crimes. But if a person is not guilty, that person should not be treated like this, in a way where the person would have to continue to respond to allegations that are unproven. It's important in terms of our sense of justice, and it's important for our system as well, justice system. Mr. Waldman, do you have anything to add to that?
Just simply that, sometimes deportation if we're concerned about bringing people to justice, deportation will sometimes be the most ineffective way of doing that. If there is no effective mechanism for trying the person in the country where he's being deported to, a war criminal can get off scot-free by being deported, and that's happened in some cases. So I think we have to consider what method is the most appropriate in the circumstances.
Merci.
Thank you. You both raised, if I'm not mistaken, audit methods that would be more vigorous before arrival in Canada. Some of these methods, in fact, could you give us an idea of the methods you'd suggest? I think the balance that needs to be struck is that it's also an economic issue. And I think your committee will have to weight that, to establish the weight for that issue. If you impose access for entry to Canada, then you're going to have an effect on Canadian tourism, on the Canadian economy. So this is an issue of striking a balance between various interests. I believe the reason why we need to continue to work along evidence-based lines is that we need to understand the economic impacts, sociological effects of the methods we're putting forward to make sure that costs do not outweigh benefits. that the cost of measures that would slow down tourism, that would slow down arrivals to Canada, actually have benefits from a safety standpoint. And we need to do this consistently. So every 5 years or so, there should be an assessment, a cost-benefit analysis done. And that's what I'm referring to when I'm saying sustained accountability. We need to have a better understanding of the evolving situation. Thank you. Mr. Waldman?
Mr. Opitz, you haven't...
Very briefly, I agree.
And you have until the bell rings. Mr. Rossier, Mr. Waldman, we will all have to leave at 5:30 to go and vote. The floor is yours, Mr. Opitz.
Thank you, Mr. Chair. I'll start with Madame de Rossier. Ma'am, some of the things you had just talked about and some of the things you suggested and the overall fairness and appropriateness and access to courts and adjudication, which is happening, and the discussion between our greater information sharing between not only ourselves and the United States but other allies, as well as the implementation of biometrics. And biometrics are like fingerprints, eye scans, which Nexus cards do. And you see people moving fairly rapidly back and forth because they have that. It sounds very much like you're satisfied with the direction we're going in to be able to accommodate these things, and then, of course, accommodate travel to Canada in a much more rapid method. Would that be a fair statement?
To the extent that there's no accountability mechanism to CBSA, our point is that I think you should do it. Like you should really put in your recommendations anytime you increase power. As you should increase accountability regime. It's just good governance. So to the extent that you're getting the privacy commissioners looking fairly at the issue and that you have a good accountability mechanism and good fairness, yes, there's no issue. But I think the accountability piece must be there, and it must be an audited, evidence-based evaluation.
Well, but that's what evidence sharing and information sharing will do. It'll help eliminate any speculation, which is what we don't want to do.
But you have to be careful, I think, on evidence sharing that indeed it is done with the proper safeguards so that the Maria case does not happen again.
No, well, I agree. That's happened with proper safeguards, proper protocols. And we discussed that on this committee for quite some time. But that's why, the biometrics would be very important, because we've had incidents of a criminal, for example, who has been deported from Canada 18 times, returned to Canada 18 times, because those systems were not in place to catch them, and for whatever reason, whether it was fraudulent passports that they put together, fraudulent papers, false refugee claims, whatever, right? People can get in.
There's always a case. No system will be perfect, and I think we know that. We're trying to improve the systems, and that's the reason why we say, invest a little bit on the accountability side so that you get better intelligence.
I'm so sorry, Mr. Opitz. The bells are ringing. I know you can't hear them, but they're ringing. So we will have to adjourn this meeting. Mr. Waldman, Ms. de Rossier, I want to thank you both for taking the time to appear at this committee meeting. This meeting is adjourned.